Before opening the file, you are saying sorry.
I have lost my file. I can't create it. Lordships, give me time, any time. I don't want to argue. Even may record it. That has been dismissed. For that, there are 2 police cases against you, and thereafter you make with giving me.
You means to me. You are saying you.
Serial number 39, Rana Umesh Prasad Singh versus the State of Bihar for the petitioner Sri Gajendra Prasad Singh.
Lordships, I'm very sorry. From my seat today.
Before opening the file, you are saying sorry.
Lordships, I have lost my file from the seat today itself. Somebody has.
Not that you yourself have lost. Only file.
Lordships.
All right, you can reconstruct the file.
There are so many.
You need not worry.
All the original papers are in that file. Therefore, I am very worried, Lordships.
Some of your colleague must have mistakenly taken. You put a notice in your bar association.
Lordships,
documents are very important.
Whom I was expecting, I had made a call to those people, but still I could not trust that.
1 month?
नहीं हुजूर, 2-3 दिन का मंडे को कर मंडे के लिए. If I don't get the file, then months would be less. But no, I'm praying let it be correct. On Monday, Lordships.
So you are assuming that file will be returned to you by
somebody must have mistakenly. Otherwise, for me,
2021, 1 month.
हुजूर, सैलरी का है, खाली इतना ही सुन लिया जाए. सैलरी का है, और पिटिशनर की स्थिति क्या कहूं.
कौन सा पीरियड? सैलरी कौन सा पीरियड?
2 periods are concerned.
Correct. Which are those 2 spells?
Under suspension, subsistence was paid.
Sir,
period
you give me the spells,
2000 to 2003 and again 2003 to 2006.
All right, I will take up this matter after 10 minutes. Read the file. Give it him.
Then
today only you argue after 10 minutes.
Even that 10 minutes is not required. What I am
10 minutes is not sufficient to apprise this court salary period for which period he is entitled.
Lordships, my very humble prayer, sir, with folded hands.
My humble prayer is, what is the for which period he is entitled to salary?
2000 to 2003 and 2003 to 2006.
Then there is no urgency. List this matter after 4 months. Call the next case.
Lordships, it would be Lordships or contrary to your Lordship's order.
Shall I record everything?
No, Lordships.
If you want me to record it, I will record now itself.
Lordship, what I am saying.
Land counsel for the petitioner submitted that his file is missing during the course of the day in the court. Therefore, he intends to reconstruct the file and is seeking time till Monday. Perusal of the records, it is evident that there is no urgency for the simple reason that the petitioner grievance is relating to entitlement of salary for the period in the year 2003. We are in the year 2022. Therefore, I find that there is no urgency in the matter. List this matter after 4 months.
May note, he has also been terminated after this suspension, and
termination is also challenged.
Lordships.
No, I can't understand. Your lordship means what?
Not in this particular writ.
Then we are concerned with only this case. We are concerned only with the salary.
And Lordships, I shall very humbly again say, heaven will not fall.
Yes.
If I have lost my file, I can't create it.
All right, take my file. Address the argument after 10 minutes. Even for that you don't want.
I'm ready.
Just now I said, then you said no. Yes, take down at this stage and counsel for the petitioner intends to address the argument with reference to the court file. List this Matter will be taken up after 10 minutes. Mr. Counsel, jot down the dates on a sheet of paper and then address the argument.
Lordships, I'm not hesitant to say, Lordships, file is not in order, Lordships.
File is not in order.
Lordships. Second order is missing, Lordships, from Lordships file. Although I have annexed that.
Now you
is,
want to address the argument or you want
Lordship,
time?
I'm addressing. That is at
Then
page
don't say
40.
all those things, sir. You please address with reference to whatever material available. I will decide.
That is at page 48. I am inviting Lordship's attention towards page 48.
Don't jump to the conclusion.
I am showing your Lordship had been pleased to direct the state to file counter.
Why counter is required?
Lordship shall...
It is the discretion of the court whether counter is required or not. First you address your case.
This is the order of Lordships. If Lordships...
If they are not filed, I will not wait for their counter.
Lordships at page 48 may come, Lordships may do anything with my file.
Sir, now I am giving you two options. One is to argue the matter. Other one is for adjournment. Which one you want?
Permitting the state to not to follow your Lordship's order dated 18/8.
You file a contempt. You file a contempt.
Lordship's contempt will not pay me my salary,
That is
Lordship.
the reason I am asking you, Mr. Counsel. I am giving you two options. Either to address the argument on the main matter or adjournment. Which one you want?
Lordships, I had been suspended from 1/12/2000 to 26/2/2003. Thereafter, 4th of September to 31st of January 2007. By order of this Honorable Court in CWJC 5252,
Read your prayer. Give the file.
my payment of my salary of the period for which I had been paid subsistence only.
Please read the file. Take the file. Read your prayer. You are asking for entire salary for the suspension period, correct?
Lordships.
Correct? Then you have been terminated from service
Thereafter.
thereafter. In that event, you are not entitled for salary.
Lordships, after
At the
this,
best, you are entitled to a direction to the official respondents to regulate the suspension period in accordance with law.
Lordships,
I think
that
Rule
has
97 or
already
something.
been regularized by your Lordships. That is an annexure, Lordships.
Regularized already.
Lordships, give me time, any time. I don't want to argue. Even may record it.
What do you want?
Even may record it that I said I don't want to argue.
Counsel for the petitioner could not assist this matter. Could not assist in the
And
matter.
for the reason that the Lordship is not ready to listen to the petitioner. Your Lordship is not ready to listen the petitioner.
Not ready to listen.
Yes.
I am given you sufficient time for the last.
Yes,
15 minutes.
sufficient time. What is sufficient time? I do understand. If Lordship wishes to invoke contempt jurisdiction, I am inviting your Lordships. Invoke contempt jurisdiction.
Why should I? Contempt for what?
I am not saying only happy words.
Well, and counsel for the petitioner could not assist this matter while giving dates and events to stop. One of the question for consideration in the present petition is regularization of suspension period.
And nowhere there is discussion of termination. Sorry.
When this court posed a question as to what is the outcome of inquiry, it is stated that his services were terminated and it was subject matter of another litigation.
That has been dismissed. For that there are 2 police cases against you, and thereafter you make with giving me.
You means to me. You are saying you.
No, Lordships. other lordships. That is annexure in my supplementary petition.
No,
That-
anyway, I am saying that the termination order is subject matter of another litigation. What is wrong with
That has been dismissed, lordships.
Ah,
That has been dismissed,
Yeah,
giving
and
me liberty
even
to
that-
challenge it again.
Even that petition is stated to have been rejected. In other words, termination as on today has been confirmed. First up, the petitioner counsel is not in a position to apprise this court against the order of the learned single judge whether petitioner has preferred LPA insofar as the termination issue is concerned. First up, in the light of these facts and
Lordships,
circumstances,
it would be a wrong order.
in the light of these facts and circumstances, the petitioner should have sought for a direction to the official respondents to regulate the suspension period in accordance with law. First up, such a prayer is not made. Such a prayer has not been arrayed in the present petition. First up, while exercising Article 226 of the Constitution, the concerned authority / disciplinary authority is hereby directed to pass an order regularizing the suspension period as a duty or suspension, and it should be in accordance with law. Such a decision shall be taken and communicated to the petitioner within a period of 3 months from the date of receipt of this order. If the official respondents have not already regularized the suspension period by passing any order, in the event of passing any order regularizing the suspension period, in that event, a copy of the order relating to regularization of suspension shall be communicated to the petitioner at the earliest. Accordingly, petitioner